No, no, no.
All right, good morning, ladies and gentlemen. Welcome back. I'd like to resume the charge conference just to hear any final objections or corrections or suggestions. I sent yesterday morning, Ms. D sent me proposed language for mitigating circumstance number 11. I think it has a different number in the instructions, but it had to do with mental health issues. And then yesterday evening, I sent a draft of the instructions as well as the issue and recommendation sheet. Have you all had an opportunity to review that? And if so, are there any corrections, objections, or suggestions from the state?
With both sets, Judge, just when we left on Friday, my understanding was that you were going to give peremptory instructions on some, but not all of the mitigating circumstances, or at least I was marking them as such, and I understand that you have done it for each one, and so we would just renew our objection to that, but understand that it's in your discretion, and so.
All right. I've given peremptory instructions for the ones that we agreed that we discussed. I did not, so far as I know, I've not given peremptory instructions for any that we indicated. For example, if you go to number D, well, let's go to number E. I'm sorry, start with number C. That is one that the language, if you compare it, say, to B, B has all of the evidence tends to show. That would be the peremptory language. C has, you will find this mitigating factor circumstance if you find the defendant's mother. So,
Okay, I see. I see it.
okay, so that's the distinction, and I think
It was late when I was reading it.
I understand.
Thank you.
And then there,
That is in the court.
right, and then there are on the list that the defense gave, number 31 and 35 were two that had stipulations involved in them.
I saw that.
And that would be DD and HH. And that has different language that reminds the jury that the facts to that were stipulated, but it still instructs the jury that it is up to the jury to determine whether it has mitigating value. All right. So any other objections or corrections or suggestions? All right, now, Mr.
Okay, I just took a few moments. I did see it last night, but I have to say it was just before I was about to head off to sleep.
Yes, sir.
And normally trying to go to sleep a little earlier than normal. Would it be okay if I just took a few moments to read through them?
Yes, sir, that'll be fine. All right, we'll stand at ease for a few moments then. There is not. Let me, so Dr. Bierman, or Mr. Bierman was tendered as an expert and received as such. I certainly could include that after the paragraph that deals with tests of truthfulness that apply in your everyday life. Just simply include language about an expert. Any objection by the state to including that proposed language? All right, I'll include the pattern instruction for expert witness into
Other than that, we have no further.
Objections. So.
All right. And I will, I'll be, again, it's my practice to provide the printed instructions, and as the instructions say, I'll also, shortly after I begin reading them, will instruct the bailiff to provide the verdict or the issues and recommendations form to all the jurors as well, so they can follow along. Anyone wish to be heard on that practice?
Is it going to be, so we hand it to them, not doing the full argument, but
Doing instructions.
Right, so as I'm reading, right, that's correct. Not before the argument. As I'm reading the instructions, I will have the bailiff distribute, well, at the beginning of the instructions, they'll distribute the instructions, and then about a third of the way in, the bailiff then provides copies of the verdict, the issues form, so they can follow along with that. So we'll do that. And so as we go along, I'll be, this morning as you're arguing, I'll be doing a final proofreading of this, and I'll bring to your attention if there are any substantive changes that we have in the instructions. All right, anything else that we need to take up before we bring jurors?
Just in terms of, I don't know as far as scheduling the break, I would probably want just a few minutes if there's no break between my argument. Ms. D will be going first, and then for just setting up purposes, I would need just a few minutes if there's not the regular break time plan.
All right, and how about for the state? Are both of you arguing? And who will be the first? All right, so Ms. Shikita, do you need a break between? All right, and we'll see. I mean, we'll take comfort breaks at reasonable intervals, so we'll see how long things go, and then take break as needed, but I'll try to make sure we get a break between you, Mr. Brown, and Ms. D. And Ms. Brown, you'll be going first, is that correct?
No, Ms. D.
Oh, Ms. D will be going first, all right. And I'm sorry, you just told me, Ms. Shikita, you're going first, all right. Okay, very well, let's bring jurors, please.
And while they're coming in, they have the television set.
Yes. All right. Good morning, ladies and gentlemen. Welcome back. As I told you at the close of your day on Friday, all of this evidence for this second phase of the trial has been presented. It's now time for the final arguments of the lawyers. Again, at the conclusion of these arguments, I'll instruct you on the law that you are to follow with respect to this phase of the trial. I'll simply remind you that that the final arguments of the lawyers are not evidence but are given to assist you in your evaluation of the evidence. The lawyers in their final arguments are permitted to argue, to characterize the evidence, and attempt to persuade you to a particular outcome. And again, I'll remind you that the lawyer's arguments must be based on the record that's in this case, and if a lawyer attempts to recall evidence or restate evidence for you and your recollection of the evidence differs from that of the attorney, you're to be guided exclusively by your recollection of the evidence in this case. In this second phase, we'll hear the first final arguments will be from the state. I believe Ms. Shakita will be starting on behalf of the state, and then after the state has concluded its arguments, we'll then hear from the defense. Ms. Shakita.
Thank you, Your Honor. Ladies and gentlemen, the expert that the defense called during this phase in this trial, in the sentencing phase, talked to you about missed possibilities, about all of the possibilities that CPS missed to help the defendant and his mother bond into a nurturing relationship. I want to talk to you about the possibilities that were also missed. I want to talk to you about the possibilities that Melissa Huggins-Jones will not get to have with her children, will not get to have after just 30 years of life. I'm going to talk to you about the possibilities of his family members that came to you in this courtroom and told you how much they value his relationship and what the defendant chose to miss out on. I'm going to talk to you about the mitigating circumstances in this case. But I want you to remember all the way back to jury selection and how we talked about mitigating circumstances. Those circumstances which the jury finds that tend to show that life imprisonment is the appropriate punishment. And every time we talk to you about those, we talk to you about considering those and determining for yourself what you believe to be convincing, what you believe to be credible, and what you believe in light of all of the evidence in this case. I want you to think about those circumstances when you think about the fact that Melissa Huggins-Jones was killed over an iPhone, over one iPhone in her bedroom that we know about. And remember that when we're talking about what should happen today to the defendant. Both Mr. Waller and I have told you this is a decision that has to be made seriously and with contemplation. And at the end of my argument, I'm going to talk to you about why some of the mitigating circumstances that you are to consider should not be convincing to you, should not be credible to you. I'm certainly not going to stand up in front of you and say that Travion Smith lived behind a white picket fence and had the ideal family situation. But who does? You didn't hear anything about the fact that whether or not you believe Miss Smith abandoned her child at a young age, he wasn't alone in this world. You heard that he had 3 older brothers that presumably are doing well. You at least heard from 2 of them. All born into the same lot. All born into that with families just like this defendant had. He was not left alone, vacant in an apartment. He had family members. He had Laura Cannon who cared for him. And I submit to you a lot of these possibilities that you heard of were the choices that the defendant himself made. Mitigating circumstances, the defendant has the burden of showing those to you. It's the only time that they have to show you something if they choose to. You're going to determine whether or not there's evidence to support that mitigating circumstances. You can determine what weight, if any, to give to each individual mitigating circumstance. And you determine yourself individually and together whether it's credible or convincing. You're bound to consider each and every one of those circumstances that's presented to you, but you don't have to find a single one convincing should you not do so. You're going to get 37 different circumstances listed to you, each by number, that you have to consider. And at the end of all of the list of instructions that you get about the circumstances, the judge is going to tell you that you can consider anything that you've heard, anything that you believe in your personal conscience is to be considered sort of under a catch-all that you can determine has mitigating value. Again, your determination is the one that's important. And as you go through each one of those 38, you're going to get a list, and you're going to say if one or more of you finds that that particular circumstance is in fact mitigating, or you feel that it has mitigating value. Now I want to talk to you about those circumstances. And I want to remind you, as you're going through your deliberations, that your job that you sort of do before all of us several weeks, almost 2 months ago, was to decide this case on the facts and the evidence as you heard it. Not merely on sympathy or compassion, but on the facts. Each one of the bulleted items that has a square is one of the items that you're going to have to consider. And I've tried to lump them into categories so that I can talk to them together without going through each individual circumstance. You're going to get a group of them, which I've determined, or I would grouped into the mental health circumstances. You're going to hear that one of them for your consideration is that Travion has previously been diagnosed with ADHD, oppositional defiant disorder, and depressive disorder not otherwise specified, and has been treated for such in a variety of settings to include psychiatric hospitalizations, alternative schools, including the Wright School, group homes, wilderness camp, and Puzzle Piece, a day treatment center. The next one is at times he was recommended for long-term residential care, which he did not receive. Turnover in mental health agencies led to Travion losing some treatment providers, and that Travion suffered from nightmares and night terrors as a child. Those are a group that you are to consider related to his mental health circumstances. Now let's talk to you about what the mental health evidence during that phase suggested. You heard from Dr. Blackshear and Dr. Evans, neither of which were qualified as experts. Why is that important? Because not a single doctor came into this courtroom and said this defendant has this and this is why. And why do I mention that to you? That should play in your mind about what weight to give to this mental health problem that the defendant has. Not a single person came in here and gave you a diagnosis that you can count on exists today. The best you heard was from Dr. Evans, who met with the defendant in the 8th grade, I believe, at the end of at the end of Longview, and said in the past he had been diagnosed with those things that you saw: ADHD, oppositional defiant disorder, and depressive disorder. And when asked what kind of medication he was taking or had been taking, recall what she told you: medication for depression and ADHD. Think of your experience. What middle schooler doesn't suffer from some sort of ADHD?
Objection.
Think of your experience.
Overruled.
And your history and knowledge of 8th graders. Not a single person said, here's what he has and this is what it means. That's why you should not find this mental health circumstances credible or convincing, considering the weight of this. You heard from the Wright School, Mr. Rich, who said that when he was able to manage his ADHD, it helped with his behavioral issues and his difficulties. I submit to you that defiance, avoidance, and fighting with your peers are not mental health diagnoses and are not problems. And that's why you should consider with a close regard any sort of mental health diagnoses or any sort of mental health circumstance in this case. All of the witnesses that came up that were in school with him in, say, the Longview Center or in the Puzzle Pieces said he was a nice kid. He was well-respecting, and you heard over and over again he got into fights, he was suspended, he was disrespectful. And that, ladies and gentlemen, is not a mental health problem. The school-related circumstances that you will be asked to consider: that he earned the Pruitt Award while he attended the right school. This award was given to students who never received a timeout and never had to be restrained. Travion responded often positively to praise and attention from his teachers and mental health workers, and Travion was enrolled in special education. I can't deny to you that he was in fact enrolled in special education from early on in his education. That was the type of education he had. You can determine whether those are circumstances that you should find to be credible and convincing and what weight to give to them. But let's talk about what other school information you heard in this case. That the Longview teacher, the math teacher, who was with him for 3 years, never saw any aggression, but he didn't know about multiple suspensions, one of which you heard was 10 days long. How did he teach him for 3 years and not know about those suspensions? I would submit to you that he cares about Travion Smith, and that is a wonderful quality, as anyone would want to care about one of their students. But the evidence was contrary to his own testimony. Dr. Evans' evaluation at Longview was that the defendant in social situations could respond to situations with more temper than the situation merits. And I ask you to consider the amount of violence that happened in Melissa Huggins-Jones' bedroom the night that she was killed. Mr. Waller's going to talk to you more about that, but even in the middle school, people were saying that he could respond with more temper than the situation merits. Again, you heard about the suspensions, you heard about the disrespectful, you heard it. The school had to be locked down because of the defendant's actions. And I submit to you that's contrary to the folks who came in here to talk to you about his behavior at school. Why is that important? Again, think about the contrary evidence when you're trying to determine what amount of weight to give these particular circumstances. Some of the mental health and school evidence overlap, but again, here's some of the things that you heard: that the defendant had average intelligence. He wasn't someone that had low cognitive functioning or was any sort of diagnosis other than average intelligence in terms of intelligence. He could be successful when he was focused. You heard from that 4th grade teacher that when she came in to that room, he really started to thrive. He had ADHD that led to his behavioral issues. Again, the suspensions and being disobedient. One of the things that the teachers told you was he would make decisions based on incentive for him. He made excuses to explain his conduct. He made decisions based on incentives for him. That's not someone who doesn't understand the consequences of his action or someone who is easily manipulated. You heard from Warren McDowell, who was the math teacher at Longview, that he would waste time. He said, that's the way I remembered him. There were times that he should be doing homework or doing schoolwork, and he wasted time. And why is that important? Because that's a conscious decision. He didn't tell you he couldn't do his work, but that he wasted time, a conscious decision. Child Protective Services circumstance that you're going to consider is that the efforts of Wake County Child Protective Services did not adequately protect Travion. And I would submit to you, there is no way that they can show that this is clear and convincing, and I'll talk to you about why. Quentin Bullock, the uncle of Travion, told you that he had called CPS. He didn't remember the specifics, but he admitted that he probably called them. And he talked to you about, in his testimony, that he was concerned about his sister Antoinette Smith's stability and about her not taking advantage of being with her children. But he told you he never had any real interaction with Travion Smith. His complaints were early on when Aaron was a small child and Travion wasn't even born. He told you that the drug use was always there, and I'm going to talk to you about drug use in a little bit by Miss Smith later, but he didn't say it was at this specific time. The best he could tell you was she struggled with it. There was one incident where they went to pick her up and they couldn't find her, and they went to a seedier area in Raleigh, but he couldn't say, I know that she was using specifically when she was pregnant. I know that she was using specifically when they were small children. Quentin Bullock wanted to do the best for his, his relatives. And remember what he told you when Mr. Waller asked him, if Travion Smith had called you that day, would you have taken him in when his father kicked him out? And he said, well, I surely would have listened. But you know what? The defendant, Travion Smith, would have had to follow Mr. Bullock's rules. Cynthia White-Janes, you heard that she made several reports. She clearly was concerned about these children, no question about it. But one thing she wasn't asked, which is interesting, and you determine what to think about it, is there was a lot of discussion with Mr. Bierman, their expert, CPS expert, about wasn't there this report that Miss Cannon was tearing up his butt for discipline? And he said, yeah. And the question I asked him was, well, you never saw any concerns from CPS about Miss Cannon's parenting abilities or concerns about physical discipline. And none of the defense attorneys asked her, well, did you think he disciplined her hard? They wanted to backdoor that one little comment in the CPS report, but she wasn't asked about whether she had concerns about physical abuse, because it wasn't an issue. And I point that out because it was backdoored through Mr. Bierman and the records. But Laura Cannon, you saw the photographs. She did the best she could for Travion Smith and Aaron before Miss Bailey took Aaron into her custody. Again, Travion Smith had options. The contrary evidence about Child Protective Services, recall Mr. Bierman's summary, which when I asked him about, he was hesitant to admit was his summary, but you read the report. In summary, the Wake County DSS provided some concrete services in the second CPS investigation and follow-up. Crucial services that could have increased the capacity of Antoinette to provide safety and nurture to her children were recommended but not offered, never offered. What does that mean? Recommended but never offered. I mean, was the CPS worker supposed to take Antoinette Smith to each and every one of her appointments? Absolutely not. You heard about the condition of Child Protective Services back in that day and the abilities that they had at that point. Nowhere in his report does he say Child Protective Services failed to protect Travion Smith. Their own expert doesn't even go that far, ladies and gentlemen, and that's why you should consider that mitigating circumstance with the utmost scrutiny, and I submit to you that the evidence isn't convincing. You heard about the CPS changes coming as a result of understaffing. All of those changes were reactive. This was a problem. Even Mr. Bierman said, my work in talking to the legislature is to fix the problems that we had. He even said those CPS workers were put into bad situations, or I don't remember his words, and of course my recollection of the facts isn't important. It's your recollection that matters. But he didn't look at anything after 2.5 years old. Why is that important to you? Don't you think if there had been reports that Michael Clark was this monster who was viciously beating his child, he would have been asked to review those? I would submit to you they don't exist. He only had a 2.5-year window to look at with Travion. And one of the things I thought was also important, and again, what you think is important is what matters here, but again and again, he was asked questions about, there had been these prior reports. Did the CPS workers share information, or do you know if they shared reporting system? And he seemed to suggest that they didn't. But each report I went through with him said, prior report substantiated, prior report not substantiated. They did pass on information. Could they have done some things differently? Probably. Did they do what they could? Here's what they did do. They gave her housing, or assisted with housing, assisted with furniture for the children, with a washing machine, with paying her utilities, with focusing her on getting some employment skills, with parenting classes, with providing for daycare for her children, recommending a parenting aide at the Exchange Club, which Mr. Bierman even went so far as to say that they helped fill out the paperwork. So that was recommended but not offered. Again, what does that mean? And Job Corps. What more could they do other than taking these children into custody? And you heard at the end of all of those reports and at the end of all of the CPS discussion, both children were placed with caregivers which the child protective worker told you they seemed to be bonded with. Let's talk about the relationship circumstances that you're going to consider. One is that Earl Dean Bailey and other family members attempted to foster relationships between Travion and his brothers when he was a child. That Laura Cannon, Travion's caregiver, was murdered on June 8th of 1998 when Travion was 5 years old. And Travion wanted a stable home life as evidenced by his desire to live with Candy Albrecht. I underline caregiver because was she really his caregiver for a period of time? Absolutely. But also consider what Miss Bailey told you. That she said that when I took Aaron into my custody, again, Aaron, a child who was raised in the exact same terrible, if you want to believe they were terrible circumstances, who has graduated, gone into the military, and isn't sitting in a courtroom being adjudged by a jury. Came into my custody at 3 years old, and it was shortly after that that I started trying to meet with or foster a relationship with Michael Clark, the defendant's father, and they were going to the same daycare. So her belief was that dad raised him. I would submit to you that there's conflicting evidence about who the actual caregiver was for a period of time. But the last relationship circumstance for you to consider is that the people who love Travion value their relationships with him. Where were they? Where were they after he was kicked out of school? Where were they when his father kicked him out of his house? And we'll talk about that in a moment. In the last phase of the trial, the defense tried to blame someone else. In this phase of the trial, I submit to you, they're trying to blame his mother and his father. Antoinette Smith, the circumstances you're to consider for her are long and lengthy. But first, that Travion's mother was homeless when pregnant with Travion. Travion's mother did not provide basic care for Travion when he was a baby. Travion's neighbors at Hairsnipe Court noticed that he was hungry and noted there was no food or formula in his house. And Travion's mother put alcohol in his baby bottle to put him to sleep. I would submit to you when you look at those, several of them are duplicative. Again, that should be what weight you give to them. I submit to you that probably there isn't a person in there, and again, your experience is what's important, that at some period in time is frustrated with a child and put some alcohol in his baby bottle. But again, you determine what weight, if any, to give to that circumstance. Some other circumstances. Travion's mother used alcohol, cocaine, and marijuana while she was pregnant with Travion. Travion's mother used drugs and alcohol while Travion was a toddler. Again, aren't these the same things? And where is the evidence that she used any of those things specifically when pregnant with Travion and specifically when he was a toddler? Lots of innuendos. She told you, I have had a drug problem for a great period of my life. Quentin Bullock believed that she had a drug problem, that she struggled with his life, but no specific evidence pointing to either of those time frames. What you did hear, and here's a couple more. Travion's mother would go years without seeing him when he was growing up, and Travion's mother would promise to come see him, but would often fail to keep the appointments. And I would ask you to consider that last one with a grain of salt, because the only person that told you about that was Christina Love, and I'm going to talk to you about that a little bit more. What you did hear, contrary about Antoinette Smith, was that the time of birth for Travion was in December of 1992. There was a CPS worker during that second report from July of 1992 to June of 1993 that worked with the family to get that housing that they desperately needed, to get her out of a shelter when she was homeless. And not a single note in there indicates that the social worker suspected, had concerns, or anything about substance abuse during that time. You heard that she went to treatment in 2002, which was 10 years after the defendant was born, probably 9 since he was born in December, but 9 to 10 years after he was born. And Dr. Evans told you that the defendant had reestablished a relationship with his mother. So I would submit to you that she was involved, perhaps not as involved as anyone would like her to have been, absolutely. But again, consider all of those things when you're looking at the circumstances related to Antoinette Smith. None of her other children have been charged with murder. All of them went to caregivers that were not her because she wasn't able to parent them. She told you when she came into this courtroom that she was struggling with substance abuse and wanted to get clean for her children, and yet none of her other children are similarly situated. So that leaves us with Michael Clark. And I want you to consider the number of circumstances that you're going to hear about Michael Clark. But it's interesting that you didn't hear from Michael Clark. The only people that came in this courtroom and talked about Michael Clark being this monster were Christina Love and her mother. And we'll talk about their testimony in a moment. But here's where we want to point the blame now. That he was this monster. That he was a terrible father, but again, not a single CPS report was Dr. Bierman asked to look at. You heard over and over again that Travion would visit with his brothers, either on vacation or going up to Franklinton, and none of them suspected abuse. Here's what you're going to be asked to be considered with Michael Clark. That Michael Clark did not want Travion to be born, as evidenced by beating and punching Antoinette in the stomach when he learned she was pregnant. And I ask you to consider that circumstance for a minute. The defense wants you to believe Antoinette Smith in some circumstances, but not in others. And again, you didn't hear that from Michael Clark. Michael Clark resented to raising Travion. I would submit to you there's not a single shred of evidence in here. When Travion needed someone, when Travion needed a place to stay, he went time and time again to his father's home. That Travion experienced physical, emotional, and verbal abuse by his father. We'll talk about the evidence about that. Travion grew up in a chaotic and volatile home environment. That Travion lacked basic skills for personal grooming and hygiene. That Michael Clark did not have the parenting skills to nurture Travion. Oops. Again, I would submit to you to discount resenting having him because there's absolutely no evidence of that. And again, I would submit you never heard that he didn't have the skills to parent Travion. I'd ask you to think about what kind of parent, what kind of extraordinary parent it might take to parent a child who is constantly being suspended from school. And then the last one is the nature of Travion's mental health and emotional problems required a stable, structured environment in order for him to be successful. And their own witness said to you, the fourth grade teacher, most homes are not structured like a classroom. There's more. Michael Clark removed Travion from programs where he was successful. Michael Clark removed Travion from treatment programs that have been recommended by his treatment providers and by educators. Michael Clark removed Travion from Wilderness Camp, the residential treatment option that was secured following the Wright School after only a few weeks, and mental health services would end abruptly for Travion as a child. Aren't these all similar? Don't they boil down to whether he was at fault? Again, now the ending of services, there was some testimony about turnover and those types of things. But aren't these the same? And again, that's why you should consider what weight to give to them. But here's what you heard about Michael Clark, even though you didn't hear from him, that he attended school meetings since the beginning with the IEP. You heard that they're reviewed from time to time and a note goes home with him and he was involved. His dad and his stepmother were active participants in the treatment team at the Wright School. That he participated in Longview psychological evaluation. There were a couple of meetings that the interviewer would then talk to Dr. Evans about. That Dad participated with the puzzle piece program per Wesley Johnson. Dad wanted to help, were his own words, and Dad didn't know how to. That they met once a month, and Mr. Johnson said, I can't recall him not being involved at all. The probation officer, even up until the very end when this defendant is being arrested, said, I thought his dad had his best interests at heart. And who did the defendant tell Detective Gibney he called right after this happened? His dad. His dad, who I submit to you the defense wants to throw under the bus in the sentencing hearing. But ladies and gentlemen, it's not true. I want to talk to you about Christina Love and Candy Albrecht. They're the only people to discuss Michael Clark's horrible treatment of Travion. Remember the words that Christina Love used in her testimony, that he was malicious, neglectful, and selfish. Who uses those words? that that his dad kicked the defendant out with malicious intent. I want you to think about her testimony. Surely she loves her brother. I'm not suggesting that she doesn't. But I want you to consider her testimony, how each time she was asked a question, she would pause, she would take a sigh, and then you determine whether those tears were real. She would stop, let me think how to answer it, and then put her hand in her head. Her head in her hand, excuse me. Not a single one of them, despite this vicious jumping, punching, treating him like an outsider that Michael Clark did time after time, did they report to Child Protective Services. Candy Albrecht made excuses to you, and what did she say? When asked by Mr. Waller, well, why didn't you report this? Why didn't you do something about it? Well, because a 6-year-old talking about abuse is different than an adult. And I submit to you, a 6-year-old would come over and say, you should hear what my daddy is doing to my brother. It didn't happen. They love Travion, as they should. But I submit to you that her testimony was over the top because she loves him, and consider that. Candy Albrecht said, I saw him here and there when Christina would visit. And then she says, he wanted me to be his mommy. Well, why didn't you do something about that? Why didn't you take him home with you if you're so concerned, Mr. Waller asked her. And what did she say? Because he said we were a package deal. That might be something to report to CPS. I'm worried about this kid's safety. He wants me to be his mother, but now the defendant's father, Michael Clark, is trying to extort me. Why wouldn't you call that in? Again, because it's over-exaggerated, and that's the way you should give to it. There are accounts of Christina's relationship with the mean Michael Clark was that my mother forced me to go 10 to 12 times a month. Well, they clearly didn't get their story straight, because when Candy Albrecht came in, she told you when he felt like getting her. Was it 10 to 12 times? No, not when he didn't want to. Again, they're trying to do the best for Travion. Who can blame them? But again, consider that with the weight that you want to give it. I talked to you about Christina Love's demeanor here in the courtroom. Again, she loves her brother. I don't doubt that. But when she leaves, always riding for my baby bro. No tears there. Old courthouse behind her. And then when people say, how's it going? Everyone keeps hitting my line, telling me I'm on the news, like I wasn't aware. LMFAOOO. What's to be laughing about when you come into this courtroom and are asked to testify in a situation where your brother could live or die? The other circumstances left to consider are that he was immature for his age, that Ronald Anthony was 23 when Travion was 20 at the time of the crime, and that Ronald Anthony arranged for transportation with Maurice Brown after the crime. Real quickly about the arranging for transportation, you heard that Sarah was the only one with a phone. Ronald was her boyfriend. It makes sense, but I would submit to you that has no mitigating value whatsoever. And then their ages and his immaturity, we'll talk about what the evidence did show. Person after person was asked about whether this defendant, Travion Smith, was a leader or a follower. Think about the people who said he was gullible and highly impressionable. Couldn't give you an example. Dr. Blackshear, well, he was easily taken advantage of. Well, why? Well, like, for example, they said one time when it's summer, it's snowing, and Travion went to the window. That's the best he could come up with. Dr. Blackshear told you that he saw him in groups of children, I think maybe 5 times, but he had this observation of him being highly impressionable, despite testifying from memory and not being able to give you a concrete example. The Wright School itself taught him leadership skills. In that Wright School evaluation at the end, when he's transitioning back into sort of mainstream schooling, you heard that Travion likes to be center stage. That's not a follower, ladies and gentlemen. That's a leader. His willingness to do something was dependent, I skipped ahead, that he was able to manufacture excuses for his conduct when he got in trouble. Again, I submit to you that's exactly what this is here. The Longview evaluation, he leaves the right school, he goes to Longview. The defendant had good insight. The defendant would do something, what his willingness, to do something was dependent on the incentives and the consequences. Miss Hubert said, oh, he was so gullible, he was so immature for his age, but she couldn't give you a concrete example either. And she had him for years, a year and a half maybe. And think about his Miss Love's testimony. She said, my brother, he was so protective of me that when I wrecked our dad's car, I knew he was going to get a whooping, and he stood up for me anyway. Is that a follower, ladies and gentlemen, or a leader? Post-August of 2009, I submit to you, haven't heard from a single person other than Christina Love who had any contact with him whatsoever. You're going to hear that one of the other, and it doesn't have a square by it, so I apologize, one of the other circumstances for you to consider is that Travion has no prior convictions for violent felonies. But none of the witnesses, none of his brothers, none of the other family members had much contact with him other than Christina Love. That you heard that he went to prison and violated his parole, that he was disrespectful and refused to obey orders while in jail, which is a structured setting, which you heard time and time again is exactly the type of situation that supposedly the defendant needs. But what you did here is leading up to that time frame, each of his brothers that came into this courtroom said, we were worried. And they didn't say specifically about Travion, but they said, we were worried because of our family that he didn't want him to stay in school and to stay out of trouble. They had concerns about where he was headed, but where were they when he was going down that path? He was skipping school. You heard Earl Dean told him, you better get back to school. The last circumstance for you to consider was that Travion was kicked out of his father's home on April 11th of 2013 when he was on probation. Where were these people if they were concerned about him to take him in? Christina Love told you I had some issues. It wasn't right for me at that time. Candy Albrecht wasn't someone on the radar screen apparently. Think about the brothers that testified and Quentin Bullock, all of whom had rules and had families. I submit to you it was easier for him to run the streets with his gang friends than to abide by the rules. Again, another sign that the defendant was motivated by the incentives for his conduct and what he wanted to do. He knew he had to find a place to stay within a short period of time. And I'll talk to you about this in just a moment as I wrap up with the rebuttal witnesses, but he made a choice. He made a choice to go to Oxford, where he told Detective Gibney when he was being interviewed, we were breaking into cars everywhere. Didn't call any of these people. But remind you, he called his dad the monster that turned him into what he is. He called his dad because his dad was always there for him, I submit to you. Again, their own witnesses, I submit to you, some of them are contradictory. Miss Hebert and Coach describe a totally different dad. Coach said he was trying the best he could. He might not have been able to do it. Hebert, they had no bond. And remember her demeanor. They had no bond. He wouldn't look at him. They were in the very same meetings. Again, for your consideration about the way to give to it. That dad didn't foster a relationship, people said, or he didn't have a bond. You heard that there were times when he would take him to Franklin County to meet with his siblings. Brothers had vacations together. And the interesting thing is they talked about whenever he would come, this would happen, or we'd be joyful. It wasn't just a once a year kind of thing. Mother's lack of involvement, they wanted you to believe that she had abandoned him. And again, I'm not asking you to find Antoinette Smith the mother of the year. But the psychological evaluation suggests that she had tried to come back into her son's life and they were working on a relationship. Talking about the feasibility of long-term treatment, Dr. Blackshear said, well, it would have been almost impossible. It would be unlikely for Medicaid to get him into that. And you heard that dad had concerns about being able to pay for that. And then Dr. Evans said, we recommended it, and yeah, it's possible that Medicaid could have paid for it. But what did she tell you about the long-term treatment options? It wasn't that Michael Clark didn't want it. She said we couldn't find an appropriate option. Not that Dad didn't want it. Think about the rebuttal evidence. Mark Shellhorn, who explained the rules to the defendant about being on parole, essentially post-release supervision. He continued to violate them. He said, if you violate your curfew one more time, I'm going to put you on electronic house arrest. And he continued to do it. His dad was concerned about the people he was hanging out with. His dad was concerned he was getting back into that life that got him into trouble. And so he told the probation officer, you need to come here later. You need to come here. And when they said, look, we're going to put him on EHA, and what that means is you're going to have to open your home up to warrantless searches anytime, the whole residence. Dad didn't say no. Dad let it happen. Dad took him in twice, not only when he got out of prison, but after he was disrespectful, he allowed him to come back into his home. The defendant let his bracelet die. When you heard Mr. Shellhorn say it's possible that he could have taken it out of county, he didn't even offer Oxford. That thing died, and he wasn't seen from again. The jail detention staff again talked to you about the disrespectful and aggressive conduct, the foul language, and again, here we are in that structured setting. Ladies and gentlemen, a lot of evidence was presented for your consideration. A lot of evidence was talked about with respect to Antoinette Smith abandoning her child, in Miss D's words, at a time in life when love is most important. That's exactly what this defendant did to Hannah Jones. A small child with a new life with her mother. And so when you think about missed possibilities, when you think about the people who came in this courtroom and wish they had done things differently, and of course they do, and I'm not suggesting that his family doesn't love him, of course they do. But he made some choices, ladies and gentlemen. He didn't reach out to his family members. He went and ran the streets. And again, this defendant is not unintelligent. This defendant can do things when he wants to, and he made a choice. And the choice he made with Ronald Anthony and those other folks that day were to take Hannah Jones of her mother at a time in life when she needed her the most. And so I ask that you consider all of this when you're considering what amount or what weight to give to the mitigating circumstances. Travion Smith did not have a perfect life, but it does not excuse, and those mitigating circumstances do not outweigh the aggravating circumstances in this case that Mr. Waller is going to outline for you now. And he is going to stand up in front of you, not lightly, not without heavy heart. He is going to ask you to find that these are insufficient to outweigh those aggravators. That violent attack over an iPhone 5 that led to children being abandoned by their mother. And he is going to ask you to consider that these are insufficient, and they are the circumstances that he outlays for you are so substantial, sufficiently substantial, to sentence this man and recommend this man to be sentenced to death.
Thank you, Mr. Keaton. Mr. Waller?
Maybe we have just one moment, Your Honor.
Yes, sir.
Mayor, ladies and gentlemen. When we finished our closing, or I finished my closing argument, the guilt innocence phase, I told you about the nightmare. She'd been struck 18 times at this point, lying there in a pool of blood, helpless. They start rummaging through her stuff there in the room. They start going through her personal belongings, that armoire. She's helpless. She's helpless because she doesn't know what's about to happen down the hall, where Hannah Jones is asleep. Helpless. Every parent's worst nightmare. Not being able to protect your child. Not being able to comfort her. Not being able to take care of her. She's helpless because of what he had done to her. 18 times. She's down the hall. Maybe Melissa screams, maybe she doesn't. She does everything she can to protect that child. But in the end, for her, she didn't know what was going to happen to Hannah. That bright, beautiful little girl that you saw last Wednesday. That little girl so full of life. And Melissa died not knowing what was going to happen to her. She couldn't help her own daughter. Not every case is appropriate for the death penalty. That's absolutely right. That's true. It takes special circumstances to bring us, even to just get us here, to just bring us to where we are today. It takes special circumstances for us to get here. But why this case? Why are we here on this case? There have to be aggravating circumstances to get us this far. Things that make us or make you decide this case in terms of the most serious thing you could ever be asked to do as a juror, to decide whether that man lives or dies. That's exactly what we're asking you to do, and Ms. Shakit is 100% correct. We don't come in here doing this lightly. It's the most solemn thing that we could ever ask you to do. But we're asking you to do it because of the circumstances of this case. The circumstances that put this to being a death penalty case. Not only what happened to Melissa that night, but also Hannah and her family. You're going to get a packet. Issues and recommendation as to punishment. And I'm going to walk you through that packet now in this PowerPoint presentation. You're going to be asked to decide several different levels or different circumstances, elements like we talked about in the first phase, in which you have to find beyond a reasonable doubt and unanimously agree that the death penalty is the appropriate punishment in this case. And it's like we talked about in jury selection. We're not going to ask you to just go back there and flip a coin. There's going to be a process, and it's going to be a tough process. It's going to require you to use your reason and common sense and your intelligence, and you're going to have to think about these things deeply. And we want you to think about these things deeply because it's the most important thing that you could ever decide as a juror. But just because it's tough or not easy doesn't mean that it doesn't qualify under the law for the death penalty. It's not supposed to be easy because it is so serious. The first issue that you're going to have to decide in this case is, did Travion Smith kill or attempted to kill the victim, intended to kill the victim, intended that deadly force would be used in the course of the underlying felony constituting the felony murder theory, again, remember back from the guilt innocence phase that we used a burglary at that point, or the burglary at that point, excuse me, for the felony murder theory, was a major participant in the underlying felony constituting the felony murder theory and showed a reckless indifference to human life. The first three, killed or attempted to kill, killed or attempted to kill, intended to kill, or intended that deadly force would be used in the course of the underlying felony. It is our contention throughout this entire trial that Travion Smith was in that bedroom and put his hands and assaulted Melissa Huggins-Jones. And that's some of the things we talked about. The nature of the attack. Two people in the apartment, both would have known what was going on. The medical examiner testifying that there were injuries consistent with two instruments. Injuries to both sides of her body. Sarah Redden seeing Travion Smith on that balcony, wiping the blood off, washing his hands afterwards, blood on his shirt, the conversation at the Super 8, what the hell just happened. Nature of the conversation indicated that both inside the apartment and Ronald irritated with Travion. Those are the things we talked about at guilt innocence. Some direct evidence, some circumstantial evidence as to why Travion Smith was in that room and helped kill, or did kill, Melissa Huggins-Jones. Melvin Brown jumped on the lady first and punched her several times, and again the shoe on the vent. Ronald being irritated with Travion. He got this whole thing started. I'd argue to you, ladies and gentlemen, there's no doubt he's the one that laid the first blow. Those all go to show, that Travion Smith was directly involved with the killing of Melissa Huggins-Jones. And that is the state's contention. But like we talked about with acting in concert, even if you don't find that Travion Smith put a hand on Melissa Huggins-Jones in that bedroom, you can still get past this issue 1A and find that yes, he was a major participant because of this fourth element to issue 1. He was a major participant in the underlying felony, constituting the felony murder, and showed a reckless indifference to human life. So again, he doesn't have to lay a hand on her for you to find this. Major participant in the burglary. They were breaking into cars together before. They both leave Sarah there in the parking lot of the Allister apartments. Sarah sees Travion on the balcony wiping it down, shoe on the dryer vent. Travion is in possession of the laptops immediately after. They leave the scene together. Travion sells a laptop, and they're together when arrested. You've already found, and I would ask that you find again, that he was a major participant in that burglary. That he took part in that burglary. And then that he showed reckless indifference to human life. Again, the nature of the attack. It's a 2-bedroom apartment. Based on what you've seen in terms of photographs of that scene, you know that there's no way that he didn't know what was going on in that room. And then the blood trail. The indifference to human life. The concern about property and stuff. The blood trail. She's already dead or dying, and he takes the time to go into the armoire, the Bible, the purse, Hannah's door, the upstairs deck rail, and then the downstairs deck rail. That's showing you just don't care. That's reckless indifference to human life. You don't care that a woman is dying in her bed in a pool of her own blood. All for some stuff. To go through a purse. Issue 1A. Do you unanimously find from the evidence beyond a reasonable doubt that the defendant himself, and again the 4 elements. I'd submit to you, ladies and gentlemen, that we have proved all of these elements. That he killed her, or was involved when killing her, or at the very least he was a major participant in the burglary, and showed a reckless indifference to human life. So you're literally going to have to write yes on a blank on your issues and recommendations sheet. And that's what we'd ask you to do for issue 1A, that he was involved with the killing of Melissa Huggins-Jones. Issue 1, aggravating circumstances. And go back to jury selection. When we talked to each of you individually, and we told you the aggravating circumstances are how we get here. The circumstances in which take this case beyond a normal first-degree murder case. That there's something more to it. And that's what we're talking about here, the aggravating circumstances. Aggravating circumstances that call for the imposition of the death penalty, or make the imposition of the death penalty the more appropriate punishment in this case. You're going to hear 2 aggravating circumstances from the state in this case. The first is that the murder was committed during a robbery. When they go into her room and take that iPhone from her using a knife, that's a robbery. You have 7 elements to robbery. Defendant took property from the person or presence of another. Defendant carried away the property, and the victim did not consent to taking or carrying away the property. Defendant knew he was not entitled to the property. At the time of the taking, the defendant intended to deprive that person of its use permanently. Defendant had a dangerous weapon in his possession at the time that he obtained the property, and the defendant obtained the property by endangering or threatening the life of the victim with the dangerous weapon. Just a few quick things to note on this. All of them are pretty self-explanatory. I do want to, look at the time of the taking, the defendant intended to deprive the person of its use permanently. You've heard that it was thrown into the woods. Well, at the time they left with that phone, they fully intended to sell it or get some money for it. So did they take it from her person or presence? Absolutely. That's where that iPhone would have been. You heard Hannah talk about it. You heard her mom talk about it. That's where she kept her phone. They came in with a knife and stabbed her and took her phone. Miss Shakita said it, and I'll say it. An iPhone 5. She gets in that position all over an iPhone 5. Think about what they didn't take. They didn't take her jewelry. They didn't take her credit cards. They didn't take her checkbooks. Why not? Because that stuff is easily traceable. You take one of these, you flash it, and you can sell it on any street corner. It's easy money. Easy money. That's what they wanted. Easy money. All of that. 18 times for easy money. That's a robbery. It's a stupid robbery, but it's a robbery. It's not like they went in there and got $1 million or anything like that. Not that that would make any excuse for it. But for an iPhone 5. Easy money. That's what they were trying to get. Something that they could go sell on a street corner. And they stab her and beat her 18 times. Many of you mentioned awareness of this aggravating circumstance during jury selection. That the murder was especially heinous, atrocious, or cruel. Basically what that is talking about is the nature of the attack. And one thing I've mentioned already, and I'll mention again at this point, is that she was helpless. The nature of the attack is what brings us to this aggravating circumstance. Where she was in her bed, ladies and gentlemen, in the sanctity of her own home. Didn't just shoot her one time. Didn't just stab her one time. 18 times to the head and neck and torso. Factors for you to consider under the law. The murder was physically agonizing or otherwise dehumanizing to the victim. A murder that leaves the victim in one last moments aware of but helpless to prevent impending death. A murder that demonstrates defendant's unusual depravity of mind. Murder committed in a fashion beyond what was necessary to effectuate the victim's death. Victim alive after attack but took no steps to assist. Further blows once the victim is down. Aware of fate and unable to prevent his impending death, or her impending death in this case. That all comes from case law. Factors for you to consider in this case as to especially heinous, atrocious, or cruel. Blows going beyond what is necessary to kill the victim. Vulnerability of the victim. Victim receiving many of the injuries while still alive. Committed using grossly excessive force. The victim was helpless. The number of wounds inflicted by the defendant. The victim died a slow death. The victim anticipated her death. The defendant invaded the sanctuary of the victim's home, and whether children saw or were likely to see the murder or its aftermath. Check. 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 All of those things. All factors under the law you can consider for especially heinous, atrocious, or cruel, and they meet every one of them. She's down on the bed, and she can't do a thing to help herself. And they kept on. They kept beating her. They kept stabbing her. They didn't stop. They left her there. Dr. Scott. 18 total blows, 12 to the head and neck, 6 to the body. Cause of death, blunt and sharp force trauma to the head and neck. Blunt force trauma to body, contributing factor. No lethal blow. Combination of blows caused her to bleed out several minutes up to an hour. Would have been conscious of injuries and impending death. Injuries consistent with 2 instruments. What Dr. Scott told you fits right into all those factors. Knowing that she was going to die and not being able to do a thing to help herself or him. Pain. Bleeding out for several minutes up to an hour. Issue 1. Do you unanimously find from the evidence beyond a reasonable doubt the existence of one or more aggravating circumstances that the capital felony was committed while the defendant was engaged in the felony of robbery? Yes. Senseless. Easy money. That the capital felony was especially heinous, atrocious, or cruel? Absolutely. That doesn't even need to be a yes. That needs to be an absolute. The next step that you'll be asked to look at is whether or not there are mitigating factors. And that's what Ms. Shakita just talked to you about. That's issue 2. Are there mitigating factors in this case? Yes. You're going to find mitigating factors. That's fine. We understand. We understand that. As Ms. Shakita said, did he have the greatest childhood? No. Yes, there are mitigating circumstances in the case. But then you go to issue 3. And if you recall back to jury selection, we started talking about a balancing test. And I call it, to many of you, a balancing test plus, in which you weigh aggravating factors and mitigating factors. And you decide which one is heavier. And you're going to hear about 38 mitigating factors. 38. We've submitted 2 aggravating factors for you. And I would submit to you, ladies and gentlemen, it's exactly what we talked about in jury selection. It's a weighing test, a balancing test. And you have to use your reason and common sense in doing this balancing test. There's no numerical value assigned to any one of these factors or circumstances. You have to use your reason and common sense. And at the end of the day, you can find those aggravating circumstances are like 2 bowling balls to 38 marbles. Just keep putting those mitigating circumstances on there, but when you put those 2 aggravating circumstances, that's what's going to happen. That's the weight that those aggravating circumstances deserve. That's how you should weigh them. There may be 38 mitigating factors, but they don't outweigh those 2 aggravating factors. And you know what's the best example of that? Again, I know that Travion didn't have the best upbringing, but guess who else didn't have the best upbringing? Aaron Magruder. His brother. The brother that we spent half a day hearing from Mr. Bierman about. Aaron Magruder's the one that did have the black eye, that did have the cigarette burns to him, that was living in the house where drug and alcohol abuse was present. The same Aaron Magruder that went to college, graduated from high school, went to college, served his country, and now has a family of his own. That's how you weigh those things. 2009 is the last thing we heard about in terms of mitigating factors, other than one, Miss Love mentioning that Travion did come by our house one time. Other than that, 2009 was the last mitigating circumstance that we heard about. This murder happened in 2013. A lot can happen in those years, ladies and gentlemen. So in determining how to give that weight to those mitigating factors, think about that. Think about what you heard about in terms of mitigating factors in 2013. May 13th and May 14th of 2013. Where are those mitigating factors? That should guide you in how to weigh those mitigating factors. What actually happened? Do you unanimously find beyond a reasonable doubt that the mitigating circumstances is or are insufficient to outweigh the aggravating circumstances found by you? I have no idea why it's worded that way. What it means is the aggravating factors outweigh the mitigating factors. Absolutely, yes. Issue 4. The balancing test plus. The catch-all. Where you make your decision. This is where it happens, ladies and gentlemen. You've gone through the process. You found that there are aggravating circumstances. You found there are mitigating circumstances. And you found that the aggravating circumstances outweigh the mitigating circumstances. And here you decide if they're sufficiently substantial to call for the imposition of the death penalty. Final hurdle, if you will. where you decide if what happened to Melissa Huggins-Jones calls for the imposition of the death penalty. This is where you make your determination. And as we talked about, it's not an educational exercise. It's not a theoretical exercise. It's real life. It is literally life and death. But again, just because it's serious, just because it's hard, doesn't mean that you can't check issue 4. In fact, if you have found that the aggravating circumstances exist and that they outweigh the mitigating circumstances and that they're sufficiently substantial to call for the death penalty, it is your duty under the law to return a death penalty verdict in this case. Your duty. And that's what you promised to do. That's why what will be 12 of you are seated here. Because you made that promise to us. You said you could follow the process. And you said if the state met its burden beyond a reasonable doubt, that you could do this. That's why you're here. That you could follow the law. No matter how tough it may be. No matter how tough it is to look at those pictures. No matter how tough it is to think about him. No matter how tough it is to think about his family. That if we met our burden under the law, that you could do this. And that you could check yes on issue 4. So what evidence is there that this case is sufficiently substantial to call for the death penalty? How intimate is that, ladies and gentlemen? How intimate is that? They stabbed her, in her cheek, in her ear. They tore her nose off. They busted her teeth out. The wounds there, just how intimate does that have to be? How much hatred do you have to have going through your body to do that to someone? That's why this case calls for the imposition of the death penalty. How much hatred does it take to get there? Not one blow, but 18 blows. At close range, they were on top of her. They didn't shoot her. They were literally on top of her in her own bed. And stabbed her in her face and tore her nose off. How does that not call for it? How does that not call for the death penalty? And she didn't do a thing to him. She's an innocent victim. She's not out on the corner selling drugs or, involved in something bad and, kind of put herself in this situation. She put herself in her bed. She went to bed at night with her daughter down the hall, and these guys come in and do this. Why? So you can go on the street corner and sell an iPod or iPhone. And they leave her there. For several minutes, up to an hour, bleeding out in that pool of blood. Just leave her there. Just left her. Didn't do a thing for her. Except for go through her stuff. That's why this case is sufficiently substantial. That's why this case calls for the death penalty. It's not a normal first-degree murder case. It's egregious. It takes it to that next level. Couldn't do a thing to help her daughter. Every parent's worst nightmare And we know they were at the door. CCBI number 14, blood on the door, the same blood that was sent off to SBI and found to belong to Melissa Huggins-Jones. They were happy the little girl did not wake up. Hannah Jones was saved by a fan. The fan in her room that she told you was loud and noisy and that kept her asleep at night. Thank God for that fan. They were happy the little girl did not wake up. Every parent's worst nightmare. 2 bodies instead of 1, had it not been for that fan. That's why it's appropriate. That's why the death penalty is appropriate in this case. Horrible, tragic, and completely senseless. Horrible. Because of what happened to her 18 times. Tragic because of what happened to Hannah Jones and her family. And completely senseless because it's all over easy money, an iPhone. I'm terribly sorry this happened to you, was what was told to Dawn Wallace and Hannah Jones. Defense counsel described this murder as gruesome many times during jury selection. Two days, 2.5 days worth of evidence in the sentencing phase. Not one witness. Not one witness came on that witness stand or came to this witness stand during the sentencing phase and told you anything about any remorse.
Objection.
Sustained.
Instruct.
Jurors to disregard.
No remorse.
Objection.
Sustained.
Request that the slide be moved.
I'm sorry.
There's a slide showing the objectionable conduct. Move that. Continue up there.
All right, I'll ask you to take it down. I need to review it before I can rule on it, but I'd ask you to move along and come back to it if need be.
Yes, sir. Issue 4. Do you unanimously find beyond a reasonable doubt that the aggravating circumstance or circumstances you found is or are sufficiently substantial to call for the imposition of the death penalty when considered with the mitigating circumstance or circumstances found by one or more of you? The 4th step. Yes, absolutely. And think about his demeanor. During the testimony of his own expert witness, Dr. Beerby, what did he do? You want to talk about putting weight on things and finding whether or not things are sufficiently substantial? Think about his own actions during this courtroom. What did he do? How serious is he treating it? He put his head down on the table. He put his head down. Not crying, just put his head down. The final thing that you will have to consider or do in the issues and recommendations is you'll have to write the word death as your recommendation. And that's what we ask you to do. Melissa Huggins-Jones didn't have a choice that night. He took that choice away from her. He took life away from her. Hannah Jones would certainly like to spend time with her mother or have her mother in her life. It's a very serious request. And we would ask that you write death on that issues and recommendation sheet. Not because it's what I want or Miss Shakita wants or anything like that. It's because it's what the law requires in this case. It's what the law requires that you impose the imposition of the death penalty in this case. Because the aggravating factors outweigh the mitigating factors, and they are substantial. Thank you for your time that you've spent. Thank you for listening to the evidence. And thank you for doing your duty as a juror. And we know it's a tough duty in this case. But it's there. It calls for it. And the law requires for it. So I ask that you return a death penalty verdict in this case. Thank you.
Thank you, Mr. Waller and Ms. Shakita. Ladies and gentlemen, we'll take a 10-minute recess until 20 minutes past 11, and we will then resume with arguments on behalf of the defense. If you would recall all of the instructions, please don't talk about the case among yourselves or with anyone else. Please don't form or express opinions about the outcome. No media or independent investigation into these matters. Please have no conversations with any parties, witnesses, or lawyers. Gather in the deliberation room at 20 minutes past 11. Everyone else, please remain seated. Leave your notepads in your chairs, please.